Jeffrey Epstein, Ghislaine Maxwell, sex trafficking of minors charges, years of allegations, leaked documents, and a belief held by many that powerful people were involved. Yet internal FBI communications now state something that cuts directly against that narrative. Investigators say they found no evidence that Jeffrey Epstein trafficked girls to anyone other than himself, with Ghislaine Maxwell convicted of facilitating abuse tied only to him. How did investigators reach that conclusion, and what does the evidence actually show? In recent weeks, previously sealed materials connected to the Epstein Files Transparency Act were reviewed and summarized by federal authorities. The central question has always been whether Jeffrey Epstein operated a wider trafficking network involving other powerful men or women. Epstein was charged with sex trafficking of minors before his death, and Ghislaine Maxwell was later convicted and sentenced to 20 years in prison for trafficking victims to Jeffrey Epstein. According to internal case summaries, investigators examined bank records, emails, witness statements, and extensive digital evidence seized from Epstein's properties in New York, Florida, and the United States Virgin Islands. They also reviewed victim interviews and materials gathered by local law enforcement. The stated conclusion: no verified evidence that Epstein trafficked girls to others, and no proof that anyone beyond Epstein and Maxwell participated in the sexual abuse of victims. That conclusion has raised immediate questions. If Epstein had so many connections, why does the record stop there? And is absence of evidence the same as evidence of absence? The internal reviews describe an investigation that was both broad and technically detailed. Agents searched Epstein's residences in 2019, looking specifically for surveillance systems, videos, photographs, and digital files that might document abuse. Surveillance cameras were reportedly found near entrances, not inside bedrooms or living areas. Those systems retained footage for only a short period, and available recordings from 2019 were deemed irrelevant to alleged conduct focused on the 1990s and early 2000s. A vast digital review followed. Investigators examined over 1 million images and videos extracted from Epstein's devices using a shared protocol. Reviewers were instructed to flag anything depicting females appearing under 30. All responsive material was cataloged and preserved. Some images contained nudity, and approximately a dozen photographs classified as CESAM were found on one device, described as material obtained over the internet rather than images of Epstein's victims. None of the reviewed files were said to show sexual abuse or identify perpetrators other than Epstein and Maxwell. Victim statements added another layer. Some victims alleged they were directed to have sex with other men or women. Those claims, investigators wrote, could not be corroborated and, in certain cases, conflicted with statements from other victims or witnesses. Approximately 4 to 5 victims accused other adult men, and a similar number accused other adult women, but investigators stated there was not enough evidence to bring federal charges, referring some matters to local law enforcement. If allegations existed, why did they not lead further, and what standard was being applied? One internal communication addressed a theory that has dominated public discussion for years, that Epstein secretly recorded abuse involving other men for blackmail. Investigators explicitly stated they found no videos or images supporting that theory, and noted that such evidence, if found, would have been used in prosecutions. That single procedural conclusion sits at the center of everything that follows. The files also address the idea of a so-called client list. An address book was entered into evidence during the Maxwell trial, but investigators stated it was not a client list as depicted in public speculation. Internal correspondence confirmed that no incriminating client list was identified during the investigation and that the Epstein case was concluded and marked inactive. Financial records were reviewed as well. Investigators acknowledged payments to models and others, but stated there was no evidence those transactions constituted prostitution or trafficking of girls or women to other men. This distinction matters legally. Payments alone, without proof of intent, direction, or exchange tied to sexual activity with third parties, were described as insufficient to support charges. Named associates did appear in internal memoranda. Jean-Luc Burnel, a French model scout, and Les Wexner, identified as a known associate whose finances Epstein once managed, were both referenced as having limited evidence regarding involvement. Subpoenas were served, contacts were made through attorneys, but no charges followed based on the available record. These findings do not declare innocence. They reflect prosecutorial thresholds. Allegations surfaced, evidence was assessed, and investigators concluded they could not meet the standard required for federal charges. But does that resolve the broader question, or simply narrow it? In criminal investigations, not enough evidence does not mean nothing happened. It means the evidence cannot meet the burden of proof beyond a reasonable doubt. Victim testimony is critical, particularly in sex trafficking cases, but prosecutors also seek corroboration, financial records, communications, images, videos, or consistent witness accounts. Where accounts conflicted or stood alone, investigators stated they could not proceed. The materials released are summaries, not the full underlying evidence. Redactions remain, and certain sensitive materials were not made public. Investigators maintain their conclusions were based on the complete record, including material not released due to privacy, safety, or legal restrictions. That distinction is essential when assessing what these documents can and cannot tell us. Members of Congress are now permitted to review unredacted Epstein materials at the Department of Justice during designated hours. Whether that review leads to challenges of existing conclusions remains to be seen. Jeffrey Epstein is deceased, and no further charges can be brought against him. Ghislaine Maxwell has been convicted and sentenced. The investigation, as described, is closed, yet public scrutiny continues, fueled by the gap between expectation and documented findings. The remaining question is not just what investigators concluded, but whether any new evidence could ever reopen what has been formally marked inactive. And if nothing changes, how will history judge the difference between allegation, proof, and belief?